Hey, out there, legal warriors. What happens if a protection order hearing does not go your way? What are your possible procedural moves, and what are the differences? Should you do them or shouldn't you? It's pretty complicated, but if you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 25 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people will get the help they need. Now, I'm a criminal defense attorney, but also criminal defense attorneys, some of us, we also do what the law calls protection orders and what the public might call a restraining order. If you are watching this video, let's hope you never have had to have a restraining order against you, a civil restraining order, and let's hope you don't need to get one against someone else. But the law that controls that, if you want to look it up, is RCW 7.105, Revised Code of Washington 7.105. It's this big old gobbledygook of a mess of a statute that basically says, hey, you can get an order against somebody by filing a petition, and there's hearings and things like that. Now, if you've been through an order hearing, you're gonna understand what I'm talking about. It's a little bit random what happens. There's a big favor. The law really favors the petitioner, the person asking for the order. It really disfavors the respondent. But in any case, when you go to this protection order hearing, you're going to hear the court talk about three things. They're going to say, hey, if you don't like my ruling, you can either move to reconsider, you can move to revise, called revision, or you can appeal. And those are the three types of things that someone can do for the most part in Washington State, whoever has lost that order hearing. If you win the order hearing, of course, technically, I guess you could still do those things, but why would you? You already won the hearing. And so I'm just going to cover the basics of what the differences are between those three options, what the general timeframes are. I want you to check the local court rule to find this out for yourself. And why is it you may not want to do any of these, or you may want to do one or two, or even all three of these. So again, let's start with the proposition that you are the person who lost the order hearing. Well, assuming that it was in front of a judge or a commissioner, it could be either way, then you can always ask for a motion to reconsider. A motion to reconsider is under the court rules, and it basically says if you file a motion to reconsider, you have 10 days from the date of the actual order that you're wanting to have reconsidered to follow the rules of the court in doing that. Now, I can't tell you what the rules are. They're different in each court. It's totally different in King County, in Snohomish County, in Pierce County. But you can oftentimes find something online or a packet that's going to tell you how to do it for each court. For example, in King County, they don't allow oral argument. They don't allow the non-moving party to even file a response without permission. In Snohomish County, they expect the non-moving party to file a response, and they expect there's going to be argument, and each county is going to be different. But a motion to reconsider, what you're doing is you're telling the same deciding judicial officer, I want you to change your mind. You're not going above their head. You're saying, hey, judicial officer, commissioner, or judge, here is what you messed up. Now, that doesn't mean we get to relitigate the same issue again. Hey, here's the same argument. Just decide better, okay? That's not what we get to do. We have to say, here's some newly discovered evidence that I didn't have prior to the hearing, and it's not my fault I didn't have it prior to the hearing. Or here's a mistake of law that you made, Judge. I want you to consider this law that either I forgot to put in, or maybe the law changed, or you just simply got it wrong on the law. It's not about, I want you to just re-decide, and I'm making the same arguments again and again because I'm mad. And some attorneys do that, and they get smacked pretty hard for doing that, and they should. So in that situation, it's pretty hard to get a court to reconsider their own ruling. It's very rare, and so that's not one that we typically favor if we are trying to do something to change what happened in one of these orders hearings. Number two, the second option is revision. Now, revision only applies if there's a court commissioner that made the decision. Now, more often than not, on a restraining order type case, it's going to be a court commissioner and not a judge, but not always. The district court is almost always going to be a judge. There's very few commissioners. And in superior court, it's almost always going to be a commissioner unless it's a certain type of order, typically a SAPO order or a extreme risk protection order are the two types of orders that the judges have to hear to begin with. But most orders are going to be anti-harassment or domestic violence. If it's at the superior court level, that's almost always going to be heard by a commissioner. And what is a commissioner? The commissioner is someone that sort of serves at the pleasure of the judges to do their dirty work, right? The judges don't have time to be listening to hundreds and hundreds of these little mini civil trials that happen for protection orders. They're doing big old trials, right? Divorces or big crimes or lawsuits, personal injury. And so they appoint these commissioners, and sometimes they're elected, but mainly appointed, to do some of these lower level things that are still really important, affect people's rights. But because they're probably less skilled, oftentimes, than the judge, the court rules say that the aggrieved party from a commissioner's decision in an order case can file for a revision. That means I'm going above your head. I'm not asking you to reconsider. I'm going above your head to the superior court judges themselves. And for the most part, there's also a 10-day rule for filing that motion to revise. Now, this is another difference we have to think about. A motion to reconsider is, hey, here's something new, or here's something that changed. A motion for revision, you can't file anything new. There's no new evidence to be decided. It's only decided on the original record that was made at the lower level. So you've got to follow all these rules. You have to provide you have to file all the record, you have to do a motion to revise, you have to do a whole bunch of stuff, but it's not for submitting new evidence. You are not allowed to submit new evidence when you're asking the higher judge in the same level court. You're not going to the Court of Appeals here. You're staying in the same level court. You're asking the judge to say, look at the exact things that the commissioner looked at, but make a different decision. Here's why they're wrong. And in that case, believe it or not, the judge has something called de novo review, which means they're looking at it with fresh eyes. They do not have to give any deference to the decision of their commissioner. It's sort of almost like starting over, but it's not totally starting over because you're only using the original record that was made below. This is not for the faint of heart. It's very hard to go through this revision process. In fact, today my law firm won a revision motion, and let me tell you, that was a ton of work. So in that situation, you have a better chance, typically speaking, on a revision if you get a really dumb ruling by a commissioner or a pro tem commissioner. Sometimes the court is really interested in making sure that that ruling gets corrected. Now, a downside is sometimes these judges don't like to see motions to revise. There's a reason why they're giving the work to the lower lanes, and they want to smack you down because they don't want to encourage you to just, have everything the commissioner does brought back up for them to look at, because why have the commissioner then? Although we are allowed to do it, but you have to pay attention to timing rules. You have to pay attention to serving rules. You have to do all this stuff, but that's the difference there. Now, finally, the third option you hear is an appeal. Now, an appeal means you're going to go to a higher level court, right? So if you're appealing from the superior court, you're going to the Court of Appeals. If you're appealing from the district court, you're going to the superior court. And an appeal, you typically have 30 days from the final decision that is made. That could be, you might have filed a motion to reconsider 10 days in, and then you lost that. Well, now you have more time starting from the date of that decision, but talk to an appellate attorney. The Court of Appeals type situation, you're asking the Court of Appeals to look at the record, no new evidence, and then decide, was there an abuse of discretion? Typically, that's not going to be de novo. They're going to give deference to the decision below. So where you get your most bang for your buck, your best chance to win if you have lost something is that motion to revise, because you're getting a de novo, a whole new look at it. Now, the Court of Appeals, you're mainly looking at that point for really terrible abuse of discretion or constitutional issues. But the appeal process, really, you're going to need an attorney for that. And the attorney's going to have to find a really clear issue terrible abuse of discretion, which means there's no way any rational judge could have found what they found on the factual claims, or a really clear error of law. And that's going to take case law and a bunch of other things that's beyond most lay people, even with ChatGPT. So those are the three type of things we have to look at. Motion to reconsider means, hey, same judge, here's new stuff, or here's what you got wrong, not re-arguing. Motion to revise, hey, I'm going above you, judge, but to the same level of court. Or I'm going to appeal to a higher court. And as you can see, each of them are difficult, but you can hopefully not have the last word be the word that you got with the ruling that you don't like. So I hope you found that useful. If so, please like and please subscribe. More people get to see it. More people get the help they need. Got a criminal matter in Washington State, feel free to reach out to my firm. If we get on board, we'll listen to what happened. We'll identify a way forward, and we will be there for you. Thank you.